Good morning, ladies and gentlemen. I hope you had a good night's sleep after the celebrations yesterday evening. Like previous speakers yesterday, I would like to start by thanking the Czech organizers for this fantastic seminar, for arranging it and for setting up the very exciting program. And I might add also for the very pleasant reception and the concert yesterday. In addition, the organizers has secured an impressive gender balance among the speakers for the conference. It's 50-50 men and women. However, this doesn't show in this panel. Since the so-called immigration crisis, or at least that was what it was called in my country, and I always wonder for who is it a crisis? Is it for the government or for the migrants? But since 2015, the Council of Europe has worked with immigration issues in several fora. We heard yesterday about the committee CDDH-MIG, which works with the codification of conditions for detention. Today you shall hear a lot about another committee, the DH-MIG. The Steering Committee for Human Rights, CDDH, got a very wide mandate from the Committee of Ministers to study human rights aspects or issues related to migration. The steering committee set up the working group DH-MIG, which I have had the pleasure to chair so far, with a more restricted mandate. The mandate was in the light of the court's relevant jurisprudence and other Council of Europe instruments to conduct an analysis of the legal and practical aspects of specific migration-related human rights issues, in particular, effective alternatives to detention. And it is this last, in particular issue, the alternatives to detention, that the committee has concentrated upon. And not like the CDDH-MIG, the DH-MIG shall not make a codification, but an analysis, a study of the possible alternatives to detention and the human rights aspects of this. Looking back to yesterday's discussions, we see that the DAM then looks at conditions of detention, MIG at alternatives to detention, but the crucial issue, whether detention of migrants and minors in special at all should be legal, it is not made, not specifically on the agenda. One might perhaps say that the time is not ripe for that issue yet. However, the aim of the work of DH-MIG is to present a practical list of alternatives to detention, being understood that states then would tend to choose these less restrictive alternatives than detention. And so today at this first session we will concentrate on this question about alternatives to detention, and we will explore the different possible alternatives. We have, as you see, 3 speakers. They will appear in a slightly different order from what is indicated in the program. First, we shall hear from the rapporteur of the DH-MIG, then a representative of the UN High Commissioner for Refugees, and finally a representative from the civil society, the Global Detention Project. The first speaker then will be Mr. Frank Schürmann. He is the Swiss government agent before the European Court of Human Rights and has pleaded and defended his country in a number of cases before the European Court of Human Rights. In addition, he has been working as professor at the universities of Fribourg and Bern. And as I said, he is currently serving as a rapporteur of the CDDH-MIG. Mr. Schürmann will also, we can do nothing here with the gender balance, but with the linguistic balance, Frank will do something. He will speak in French. You have the floor, Frank.
Ladies and gentlemen, dear colleagues, it's both a pleasure and an honor for me to take part in this conference, and I would like to extend my thanks to the organizers for their very warm welcome here in Prague, and for having taken the initiative to discuss a very topical and delicate issue which is at the very heart of human rights. I have the privilege of speaking to you, and I will do this in my personal capacity. And if I have this privilege, it's because I am the rapporteur of an expert group of the Council of Europe, which is called the CDDH-MIG, the Steering Committee for Human Rights dealing with migration. Mr. Ruud has already reminded us what the terms of reference of this group is, and this group, with the support of its secretariat, is currently preparing a draft report. This report, in fact, won't only concentrate on the detention of children, but they do, in fact, receive considerable importance here. And we will, in fact, also focus on the legal framework in which immigration detention takes place as regards children. Now, in keeping with the terms of reference, specific emphasis will be placed on the case law of the Strasbourg Court. As regards the admissibility of the detention of children, as we have seen yesterday, in fact, views are heading in the same direction, inasmuch as all sources advocate a restrictive approach. Nonetheless, I would like to point out some slight differences. There are some who, in fact, use words which amount to categorically ruling out admissibility, and others allow the administrative detention of children in principle, but only on an exceptional basis for a very limited length of time, and provided that the enforcement conditions are, in fact, adapted to the child's best interests. Now, the second slightly different position, in my opinion, has regard to the dilemma which, in fact, the Strasbourg Court has referred to on many occasions. And this dilemma, in fact, has to do with accompanied minors. These children, in fact, should not be placed in detention, but at the same time, they should not be separated from their parents. This separation can also raise a problem in terms of human rights from the standpoint of the right to family and private life, indeed possibly as regards the prohibition of inhuman treatment of these children. And I would like to recall in this particular context that the court, when it comes to transfers under the Dublin regulation, has required that the receiving state should provide a safeguard to the effect that children will not be separated from their parents. Tarakel of the Grand Chamber, in that case, the court found against Switzerland because, in fact, it had not obtained the safeguard, the guarantee from the Italian authorities that the children wouldn't be separated from their parents. Now, to get round this dilemma, it is necessary to consider alternative measures for the family as a whole, and this becomes vital. And in fact, the court has established some very strict conditions in that respect, and I'll revert to that later on. Now, if we acknowledge that the detention of children can exceptionally be allowed for a short period of time, the enforcement conditions, nonetheless, become paramount. And indeed, it's in that context that I'd like to refer to the very important work carried out by the CJDAM, which Mrs. Rossini spoke about yesterday. Now, I would like to speak about two specific aspects which are dealt with in the report. The first has to do with the legal framework in which these alternative measures should take place. And secondly, I would like to dwell on what is described in the draft report as the essential factors for effectiveness. So first of all, the legal framework. The fact that a measure cannot be described as detention because there is no deprivation of liberty means that we are outside the relevant safeguards, namely outside Article 5 of the European Convention, Article 9 of the Second Covenant, but nonetheless we fall outside the protection which is afforded by other human rights. Let us just look at the list which we see on the screen, the non-exhaustive list of alternative measures, such as this appears with certain slight differences in a number of instruments and studies. All of these measures, in fact, fall outside the realm of deprivation of liberty. I would hasten to add that one cannot, in fact, exclude a combination of many of these measures which might be applied for a certain period of time can nonetheless amount to a deprivation of liberty. I would just like to refer to the case Guzzardi against Italy, which the court ruled on in 1980. And I believe that here, the report adopts an approach which is slightly different from the one which was presented yesterday by Mrs. Alvel, who spoke about detention as from when somebody cannot freely leave the place where he or she is placed. Now, the other definition of the deprivation of liberty is narrower and in fact has regard to the court's case law, inter alia Article 5. So what is the legal framework which we should look at? I would like to mention 5 general conditions and 3 specific safeguards, and this is not exhaustive. So the first general condition, which in fact was already touched on yesterday by Mrs. Power-Ford, but which is sufficiently important to warrant being mentioned again today, is the obligation to examine in each individual case whether alternative measures would suffice. And indeed, it's precisely in the context of in the context of the detention of children that the Court of Strasbourg spelled out this obligation. In many cases, it concluded that the fact that alternatives to detention were not examined constitutes per se a violation of the Convention. And the raison d'être for this case law is very clear. It sets out to reduce the very genuine risk in practice of an automatic approach of detention in the area of migration. And indeed, the Commissioner spoke about this automatic measure yesterday. Now, another general condition, the list of alternative measures is not an à la carte menu. Here we're speaking about the enshrinement of the principle of proportionality. One cannot use a more restrictive measure if another less restrictive measure allows us to reach the necessary goal. Third general measure, alternative measures shall respect human dignity. And the fact that one is not detained doesn't guarantee per se the respect of this safeguard. And indeed, on several occasions, the court has demanded decent living conditions for people who, in fact, had not been deprived of their liberty, and to have regard to their vulnerability. For example, I'm thinking about the case MSS against Greece, and there the applicant was in fact liberty, and I'm thinking about Tarakel regarding living conditions for children in holding center. Next, alternative measures should be applied without any discrimination whatsoever, which is obvious. A different application of alternative measures based, for example, on the national origin would only be admissible under very strict conditions flowing from the relevant safeguards. And I hasten to add that it's difficult to imagine how those conditions could be fulfilled in our context. One last general condition I would like to mention: alternative measures need to be subject to a review before a national body. And this body has to be sufficiently independent vis-à-vis the deciding authority. According to other sources, it's actually a court which has to undertake that review. Now, let's have a look at some certain specific guarantees. Now, several measures, in fact, lead to a restriction of liberty, such as the placement in a reception center, in open or semi-open places, regular reporting, or again, the obligation to remain in one's domicile. Next, the right to respect for private and family life, the respect to one's home and correspondence. And there I can think of several cases of an application, for example, living conditions, the contact amongst members of the same family, interference with private life, which results from electronic surveillance, interference with the home because of the regular visits by the immigration authorities, or again the prohibition to communicate using a mobile phone. A third specific safeguard I would also like to mention has to do with measures such as bail or bonds which need to be provided. This is similar to electronic monitoring and flow from criminal proceedings, and can also raise issues as regards the guarantee to the right to property. Now, an interference with these measures can be justified according to the well-known conditions. In other words, this interference has to be provided for by law, has to be based on the law, has to pursue a legitimate aim, and as the relevant texts state, it has to be necessary in a democratic society. Now, the legal basis, I think this is interesting, in our context, fulfills two roles. First, it governs the alternative measures in a law rather than applying this on a basis which is more or less consistent or well known. It can foster a more frequent application of these measures. And I would also like to refer to the 5-point plan of the Commissioner for Human Rights. The first point on this plan, indeed, is to provide for alternative measures in the law itself. Failing which, if there is no sufficiently clear and accessible legal basis, the interference is immediately unlawful. So that's the second function, regardless of whether there is a legitimate aim or not, and regardless of the proportionality of the measure concerned. In that context, I would like to quote a recent judgment handed down by the Strasbourg court, where the court found a violation of Article 2 2 of Protocol number 4 regarding freedom of movement on the grounds that Italian law, in fact, did not clearly foresee this alternative measure. And the court, in fact, didn't look at whether the authorities pursued a legitimate aim or not, or whether the measure was proportionate. Maybe it was. But in any event, the legal basis is the absolute prerequisite. And in the case Maciej against Italy, which in fact did not have to do with migration, the court recalled its case law regarding Article 2 of Protocol 4. Sorry, I'm trying to move to the next slide. Yes, thank you. So here on the screen you can see the main principles of our case law relating to Article 2 Protocol 4, freedom of movement. In fact, means that any measures likely to infringe this right or to limit its exercise are prohibited if they do not fulfill the requirements of a measure which can be deemed to be necessary in a democratic society. For the time being, and I speak subject to the members of the registry of the court who are present here, it seems to me that for the time being the court hasn't yet been called upon to rule on cases which have to do with Article 2 of Protocol 4 in the context of migration. Nonetheless, there are certain exceptions in practice. In Switzerland, we had a discussion about the lawfulness of a measure taken by a town which amounted to prohibiting asylum seekers from, in fact, visiting certain public areas, such as the public swimming pool or the sports facilities just outside a school. This case, in fact, was settled outside court. It would have raised a problem in several respects, including from the standpoint of the freedom of movement. Now, to sum up, I'd like to say that the cause of alternative measures is somewhat ambiguous. Seen from the standpoint of a detained person, one would tend to want to open the doors wide open and to promote as best these alternative measures. And from that standpoint, alternative measures, by definition, are desirable. But when you go through these doors, you don't in fact enter into a legal vacuum. Now, seen from the standpoint of a person who is not affected by any restrictions whatsoever, many of these measures have to abide by certain conditions in order to avoid their running counter to any human rights. The analysis which the MIG group had to undertake also covered the practical aspects of the implementation of alternative measures. And in that respect, the draft report, first of all, dwells on what we call the essential factors for effectiveness. The detailed program of our conference notes this quite rightly. Alternatives to detention in the area of migration, to a great degree, remain unimplemented, and this has to do probably with doubts as regards their effectiveness. And therefore, in this part of the report, we set out to identify the conditions which would be likely to promote a more frequent use, a more transparent and consistent use of these measures, whilst at the same time ensuring their effectiveness. That is the challenge we face. Therefore, in that context, a comparison with alternative measures to the criminal detention is very telling. First of all, in terms of the legislative techniques, codes of criminal procedure, in fact, have a full list of alternative measures. For example, in the area of migration, however, these measures are very inconsistent and, in fact, are to be found in several separate provisions. And moreover, the perception of alternative measures is not at all the same in the two areas. neither from the standpoint of the authorities which are concerned, nor from the standpoint of the general public. I'm not saying in any way that everything is fine in the area of criminal law and criminal procedure, but I believe that the awareness of the legal obligation to have regard and, if need be, to apply alternative measures is more present in criminal proceedings. And I also have the feeling that the review by the courts is narrower in the criminal area. Now, the prerequisite of any detention on remand is the suspicion that a person has committed a crime. That condition is not imposed when it comes to administrative detention. Moreover, in general, the degree of vulnerability of the persons concerned is not comparable. Now, before we identify essential factors, I believe we need to spell out what we mean in this context when we speak of an effective measure. The relevant studies highlight several indicators which are used in order to measure this effectiveness. And indeed, these indicators give us a certain idea of the potential advantages of alternative measures. Now, indicators are the impact of the decision on the immigration status, whether or not the migrants have complied with their obligations. Inter alia, I think about the obligation to make oneself available for the authorities to cooperate with them. Another indicator, the respect of human rights, facilitating return, and last but not least, of course, the costs of the said measures. The draft report identifies as essential factors those which you now see on the screen: an individual assessment and screening of the individual, the person's access to information relating to his or her rights and procedure. Thirdly, very important, one has to ensure access to one's rights, inter alia via legal assistance. Fourthly, one has to foster a spirit of fairness and cooperation by providing coaching or case management services, and of course compliance with human rights. Now, if we compare these factors with the indicators of effectiveness which I have just mentioned, we clearly see that the implementation of these factors doesn't necessarily mean that there will be heightened effectiveness in every respect. That being said, there are certain issues which are relatively clear. The risk of a violation of human rights is higher in detention. A day of detention is more costly than a day spent in an open facility. And creating a spirit of trust, of course, has better regard to human dignity than a regime whereby one tries to see whether one is being disobedient or not. On the other hand, in order to be fully objective, one should also acknowledge that the relations are not always that clear. Access to legal assistance can sometimes foster return in certain cases, but not always. Allowing children to go to school complies with their right to education, but of course can also entail certain costs. Likewise, when it comes to the individual assessment of a person's situation or needs, and tailor-made needs require the offer of all sorts of solutions, placements, and support systems which would correspond to the profile of each individual and each family. By way of conclusion, ladies and gentlemen, of course, our conference won't be able to solve all the issues that we're here to discuss, but nonetheless, it might give us some indications and guidelines for future work, in particular, the work to be carried out by our group, the CDDH-MIG, which in fact should set out to, bring the reality of alternative measures more closely in line with legal standards. To that effect, the Commissioner, in fact, has indicated the avenues we should follow in his 5-point plan. I think it's also very important to show to the decision makers, the lawmakers, the immigration authorities that the goals relied on in order to justify administrative detention, such as diminishing the risk of absconding, encouraging people to cooperate, can be achieved in the same way, possibly even better, if one applies alternative measures to each individual case. And needless to say, these measures are not more costly than administrative detention. It seems to me that practical, additional exercises would be, no doubt, very useful in that respect. And when it comes to children, in particular, if I look at the subtitle of our conference, I would say, yes, detention should come to a close, with one exception, exceptional circumstances whereby one does not wish to separate children from their parents. Thank you for your attention.
Thank you very much, Frank. The next speaker will be Maciej Fagasinski. Maciej works at the Office of the United Nations High Commissioner for Refugees, where he coordinates a project called Global Technical Assistance and Capacity Building Program to prevent the detention of children and to protect children and other asylum seekers in detention. He has previously served as a consultant to a lot of international organizations, UNICEF, ODIHR, UNHCR and UNDP, and has also worked for the NGO sector. So we are looking forward to you share some of your experience. You have the floor, Maciej.
Thank you very much. I would like to thank the organizers for inviting UNHCR to this very interesting and needed conference. And I would like to share today some of our experience related to work on the ending of detention of children. And also I would like to present some practical examples related to proper care arrangements and alternatives to detention for children and families. So basically my presentation will be divided into two parts. The first part will tackle on the global strategy beyond detention, which is implemented by UNHCR. And the second part will present some practical examples on proper care arrangements from non-European countries. So I'm taking you all for a nice trip around the world, and hopefully these examples will be interesting for your work. So basically in 2014, UNHCR decided to launch a 5 years strategy called Beyond Detention. We are working with the governments in many countries around the world to support them to end the detention of asylum seekers and refugees. We have many countries around the world, many of them in Europe, but also in Asia, Africa, and the Americas. Our goal is to assist the authorities to make the detention of asylum seekers and refugees an exception rather than a routine practice. This is why we set up 3 main goals for our strategy. And one of them is, of course, ending the detention of children. The other is to ensure that alternatives to detention are in law and practice. And the third is to ensure that there are proper conditions in detention facilities and various actors have access to detention facilities to conduct monitoring visits and to check whether the detention facilities and conditions therein are in line with international law and standards. Within the global strategy, we decided to develop certain tools and activities that will be helpful for the authorities and other stakeholders, basically to to follow or to implement our three main goals. So we are doing several activities and implementing or developed several tools that will be helping or supporting the authorities to end the detention of asylum seekers and refugees. So first of all, we are trying to assess the situation and identify the main challenges in all 21 countries involved in the global strategy beyond detention. We also work with these countries on advocacy-related issues. We are trying to reach out to the authorities and to other stakeholders, raising awareness about detention and proper care arrangements and alternatives to detention. We are also concentrating on capacity building, so we would like to spread and promote certain good practices related to ATDs and proper care arrangements, especially for children and families with children. And finally, we would like to promote and to support the governments and other stakeholders in conducting monitoring visits to immigration detention facilities. Every year, we are publishing so-called progress report that collates information from all countries involved in the global detention, beyond detention strategy. And you may find there many interesting information that could be useful for your work as well. We are listing all advocacy activities. We are listing their case law that were in that happened in these countries in a given year. We also published a global strategy and to support government to end the detention of asylum seekers and refugees, which is the document on the very left hand. And you may find there various list of activities and more information about the global detention strategy. As you know, and if you don't have a copy yet, you can find it on our site event. We developed and we are extensively promoting our handbook on monitoring immigration detention. It's quite comprehensive handbook, and we aim at showing how the monitoring of immigration detention should look like, and what kind of practical examples various actors could implement in their respective field to conduct proper monitoring visits. We also, of course, develop certain policies on immigration detention that are available and could be accessible on our webpage. We're also trying to develop certain tools to identify or to support identifying various vulnerable groups. So we have a vulnerability screening tool, which is a tool to help identify and address the needs of persons in situation of vulnerability or risk. You have various tables and charts there, so it's quite easy to follow, and based on that, various stakeholders, including authorities, could assess and implement and basically address the needs of vulnerable persons. Another checklist that we have, and it's quite new, it was published in June this year. We publish very short detention checklist with several questions assisting in assessing whether a detention meets international standards and conditions. There are several questions. This is a free-pager that could be used by basically anyone to see whether immigration detention meets international standards. This year we also published a tool to identify stateless persons in detention. You also have several checklists and charts included, and it's very helpful to identify and address specific needs of stateless persons in detention. We're also trying to raise awareness on ATDs and proper care arrangements for children. So we develop a short animation that you can also see here, and it promotes, this animation was developed together with our partners. It promotes various examples of ATDs and proper care arrangements for children, and you can see it here as well. Next year, during the first quarter of 2018, we are going to publish 3 learning programs related to detention. The first one will be on fundamentals of immigration detention. It will be an e-learning available for UNHCR and non-UNHCR staff. It's quite long. It will take around 3 hours to complete it, but it's quite comprehensive and presents real fundamental issues related to immigration detention. Another learning programs will be more advanced. One of them will concentrate on ATDs and the other on doing and conducting proper immigration detention monitoring. They will be available in 4 languages, in English, Spanish, Arabic, and French. And so we are going to promote them widely next year. And hopefully, if you have time, I am encouraging you to complete at least one of them. Currently, we are also implementing a project which is funded by the European Union. We selected 5 countries around the world. These are Malaysia, Indonesia, Macedonia, Iraq, and Mexico. And we are going to conduct around 200, in total, 200 awareness-raising sessions, roundtables, both for stakeholders and the authorities, to promote ATDs and proper care arrangements for children and children with families. This project started in 2016 and will end in February 2019. We have basically reached out to various stakeholders in these countries to promote very important issues related to detention and ATDs. Of course, UNHCR also has been developing various policy documents, and you can find good examples in our 2 papers, option papers, one of them on care arrangements and alternatives to detention for children and families, and the other on open reception and alternatives to detention. These are very practical papers. You may find good examples from many countries around the world, and hopefully these examples will inspire you to implement it in your respective countries. Recently, UNHCR also developed and published its position on the detention of refugee and migrant children, and we are quite clear saying that children should not be detained, and if detention is never in their best interest. This is why we are promoting and we are encouraging various actors to implement proper care arrangements instead of detention for children. And now I would like to take you to different countries around the world and present good examples and good practices related to proper care arrangements for children. I will start with Yemen, and we managed to identify there a very good practice. Asylum-seeking children are put together with their peers in a group care places. These are houses where they are accommodated. These houses are placed close to families who take care of these children. Of course, there is full freedom of movement. Children can come and go, and they are supported by identified and trained families in this country with a quite difficult political situation nowadays. Another interesting examples were identified in Indonesia and Israel. There are residential care arrangements in these 2 countries. In Indonesia, there are 5 shelters where unaccompanied and separated children are placed. Boys in separate shelters and girls in one specific shelter designated for them. What is interesting is that also asylum seekers and refugees are engaged to run these shelters, so they serve as guardians. They are present there 24/7. They usually speak the language of those who are accommodated in these shelters, and they are supporting them in basically every aspect of their daily life. These shelters are run by a local NGO, and this NGO employs both psychologists, social workers, and child protection officers. They are there every day. There is also a guard who is present 24/7. In Israel, unaccompanied and separated children are placed together with Israeli peers in so-called villages. These villages are quite big. There could be around 300 persons accommodated there. But what is interesting is the fact that these children are placed there together with teachers, psychologists, and staff who runs these villages. So basically they are there together, they are provided with education, they can come and go, they are provided with special care arrangements tailored to their needs. Another good example related to guardianship was identified in Argentina. A guardian is appointed within 48 hours after a child is identified as unaccompanied or separated. And it takes, this person is responsible basically for all issues related to this child. So basically, the person advises on different aspects related to asylum procedure, and also assist children, a child with all daily life aspects like accommodation, healthcare, enrollment in a school, or recreational activities. The guardian is also responsible for providing legal assistance to a child, and these good examples were also identified in Uruguay and Mexico. In Uruguay, a guardian is responsible for providing all legal-related assistance to a kid, and what is also important is the fact that any activity which is not taken place in the presence of a guardian is not valid. So basically, the guardian has to accompany a child to various actors, and he has to be or she has to be present. Otherwise, the activities are not valid. In Mexico, on the other hand, UNHCR provides information to separated and unaccompanied children. There is a special animation developed. And what is also important is the fact that this animation is followed-up with an interview with a kid. So basically, our colleagues are checking whether children understood properly what is being said in the animation, and they are available to answer questions and talk with children on their specific needs. In Costa Rica, there is a group composed of Child Protection Institute, UNICEF, UNHCR, and Migration Authority, and they together conduct the best interest determination procedure. It is a good practice to gather these stakeholders to develop a tailored assistance for children. In Canada, on the other hand, in Quebec, there are 2 social workers appointed. One of them is responsible for legal related issues. So the guardian provides legal assistance, assists the child with the asylum procedure, with providing evidences and supporting the asylum claim. On the other hand, the second social worker is responsible for psychological assistance, for providing proper care arrangements for a kid. They work together quite closely. They are coordinating their work, and I believe it's a good practice that could be implemented in other countries as well. Last but not least, in Nicaragua, in 2011, in Article 10C of the Refugee Protection Law, it was clearly stated that children, unaccompanied and separated children, cannot be detained. And together with other persons in situations of vulnerability or risk, they have to be immediately provided with proper care arrangements. And I believe these examples could basically inspire you and serve in your work. And if you need to gather more examples that we managed to identify, please visit our webpage. I also encourage you to go to our stand and take materials that could be helpful in your work. Thank you very much.
Thank you, Maciej. And the third and final speaker in this session will be Michael Flynn. Mike is Executive Director of the Global Detention Project based in Geneva. He holds a BA in Philosophy and a PhD in International Studies from the Graduate Institute of International and Development Studies. He's also the editor of a recent book called Challenging Immigration Detention, Scholars, Activists and Policymakers. Michael, you have the floor.
Thank you very much for that introduction. Thank you to the organizers of this event for inviting me, to the Czech Ministry of Justice, to the Council of Europe, and also thank you to the fellow panelists for those very informative presentations. It's good to know, it's good to see the work that the CDDH-MIG is doing in trying to refine and clarify what can be or what should be considered alternatives for detention. It's also good to see the great work that UNHCR is doing in trying to move beyond detention in their work. I have the unenviable task of advancing an argument that probably few people in the audience agree with. And that is that I'm a skeptic about alternative to detention. But to be clear, I'm not a skeptic of the need to develop rights-based measures to accommodate children outside detention, but rather I'm a skeptic about whether or not alternatives, as they're framed and have been framed to date, can be an effective tool for ending the detention of children. So, at least for my presentation, I'd like to frame it not as alternatives as an effective, beneficial tools for states, but rather, can we see them? Is it possible to define them as tools for ending the detention of children? And I think the evidence to date is not encouraging. And my presentation will talk about some of these issues that I think have prevented alternatives from being effective at ending the detention of children. And I want people to keep in mind when I make this presentation that it's a difficult one to make because it's the enormous energy and investment that has gone into this campaign globally is impressive. And so I don't raise these questions lightly, but I think they nevertheless need to be considered as we move forward. My presentation can be summarized in the following way. If immigration detention is never in the best interest of children, then not detaining them should be framed as an obligation, not as an alternative. This raises the question of whether it is possible to develop alternatives to detention in a way that does not bolster the logic of detention itself. How have states exploited this paradox by developing alternatives that fail to move policy and practice away from prioritizing detention? Are there long-term unintended consequences of advocating alternatives? And what would be ideal characteristics of an alternative policy that is effective at ending the detention of children? Before I jump into the presentation, I want to just say a little bit about where I work. For those of you who aren't familiar with the Global Detention Project, we are a research organization based in Geneva, Switzerland, that documents the use of detention as a response to migration and refugee movements and promotes the rights of detainees. We do this through 4 central pillars of work: by fostering transparency in detention policies, by promoting respect for fundamental rights, by attempting to reinforce advocacy of detention reforms, and by encouraging policy relevant scholarship. Our work, all of it, is published on this website, in which you can find detention profiles on nearly 90 countries. We publish a working paper series, which has been collected in the volume that has been recently published, Challenging Immigration Detention. We also regularly provide submissions to UN human rights bodies that highlight specific gaps in states' adherence to their international legal obligations. And you can find all that information on this website. Behind the website is a database. And this database is called the Global Immigration Detention Observatory, and it's where we work with partners on the ground to develop, in as near time as possible, data on immigration detention across several different pillars of information. I won't get into this now because it'll take too much time from the presentation, but I would be eager if anyone's interested in knowing more about this database and what we do and why we do it. I'd be happy to talk with them outside this event. To date, we have documented information on some 2,000 sites of detention in about 90 countries. That is the map to date that we have of in-use detention facilities. Again, it's something we can talk about outside this event. So, what are my concerns about detention, alternatives to detention, and why to date they haven't been effective in ending the detention of children? I think there's 5 main reasons. I think there's a lack of clarity, there's a lack of clarity what are alternatives to detention, and that lack of clarity makes it very difficult to assess their impact. I think that there is a slippery slope in the logic of alternatives to detention that leads ultimately to seeing liberty as an alternative, which is a problem. Alternatives are also being used in a way that expands the surveillance state, but does nothing to limit detention itself. Countries adopt these policies, and then they do nothing to actually limit the number of people they're placed in detention. There's severe challenges to applying alternatives in transit state situations. And ultimately, arguably, the way we frame alternatives bolsters the logic of detention itself. And I'll conclude with some thoughts about the way forward. Okay, so, lack of clarity. For those of us who have been involved in assessing, studying, investigating immigration detention these last 10, 15, 20 years, we've been plagued with the problem of what is immigration detention. And I would argue we still don't know. We still need better definitions of what we mean by this. And part of the problem is that states like to call it anything but detention. And this has implications in the rights that people have in these facilities. The same thing with the same problem I think we find in alternatives to detention and how we define the detention of children. What are alternatives to detention? According to one perspective, they are anything that helps prevent detention. But as I'll point out, that's quite problematic, not only from the perspective of being able to measure its impact, but also with respect to losing the narrative of what it is. Ultimately, the language of alternatives has been hijacked. And can we get that back is a big question that we must confront. Because have we already lost it? The nature of the words themselves are problematic in this respect. And then to measure it, we also need to have a better idea of what we mean by the detention of children. Yesterday we heard from some of the speakers problems with, like, the European Court of Human Rights. How does it determine whether or not certain measures of detention are adequate to the needs of children? And it's on a case-by-case basis. To adequately know if we're detaining children requires arguably a case-by-case basis of analysis, which is impossible to do. And it's not so easy as saying, well, children have been placed in a different custody. They're no longer in immigration procedures. They're with the social welfare institution, which then placed them where? What kind of facility? And also, what do we want to say about unaccompanied minors? Are we going to just have a rule that deprivation of liberty amounts to detention when it only is reasonable that you would lock the door on a 5 or 6-year-old and not say, go run out in the street? Especially one who may be the subject of trafficking. So the questions are numerous and challenging, and they're there in front of us, and they need to be addressed in order for us to move forward on this issue. The other problem with this lack of clarity is the lack of transparency. As we heard yesterday, efforts to get information from governments is really difficult. And it's a combination of things. I think on the one hand, some states are embarrassed. I think they don't want to talk about what they're doing. I think on the other hand, there's laziness. I think people don't collect statistics systematically. And there's also the issue of getting access to facilities, and finally going back to the issue of what do we want to call detention. I'll move on. So we did a study a few years ago in which we tried to get details from 33 countries. We asked 3 very small questions. Where are people being detained? How many asylum seekers? How many children? The results were not heartening. We used freedom of information legislation. We repeatedly made these requests over and over again through every possible manner of doing it. We called, we sent emails, we sent normal mail, and this was what we got. And this is quite shocking. So, the other problem with the lack of clarity about this issue is that we very easily fall down a slippery slope in what we mean by alternatives. In some cases, we hear that alternatives are the provision of asylum. Really? In one case recently, the GDP was asked to review a document in draft form circulated by a UN committee looking at the principle, trying to establish principles and guidelines on the human rights of migrants. And the section on detention began, legislation should include the obligation of administrative or judicial bodies to start from liberty as the first alternative. I think that's a bit shocking. And I think we should wonder why that even snuck in there. What was it that leads to that formulation? Alternatives as an expansion of the surveillance state. The United States is the best or worst case of this. Today, we know that ankle bracelets are an officially considered alternative to detention. But even more importantly is that the Trump administration has recently eliminated some Obama-era case management for families and has basically put in a much more restrictive alternative measures, including ankle bracelets for mothers. To which the Detention Watch Network in the United States, which some of you may be familiar with, said, as a basic litmus test for whether or not they are being used correctly, alternatives must always decrease the number of people in detention. And I think that's a good rule of thumb. Instead, as ICE's budget for alternatives has increased, so has its budget for detention. The case of Malta is also instructive. Its 2015 strategy for the reception of asylum seekers provides that immigration officers can order alternative measures when they don't think the people should be detained. UNHCR commented that these regulations lack clarity, particularly because the measures are applied when no detention decision has been taken in the individual case. And that's critical. I think that's a critical element of alternatives. In short, the conditions outlined in the new policy document appear to be alternatives to liberty rather than alternatives to detention. Challenges in transit states. We heard an interesting case about Greece yesterday, which I think succinctly put the problem on the map for us. A more problematic way of looking at this that Xavier mentioned to me outside of the meeting yesterday was, well, you know, alternatives could work for certain transit states because they want the people to move on, which is a kind of a disturbing way to turn the perspective. But the case of Mexico is also particularly disturbing in this regard. In 2015, it launches a pilot ATD program, and then it ends up detaining more people than in its history. Obviously, there are other factors that cause that. There were significant migratory pressures, but nevertheless, they used their ATDs, and they continue to use this as a way to sell themselves as a rights-abiding institution. We saw them recently at the Committee on Migrant Workers. They appeared a couple weeks ago in Geneva, and they talked about how they have these great programs for minors, and yet they're detaining 30,000 of them. 40,000 of them. And they use it, but they use it to sell themselves. And I think that's a problem we should also think about. How are you going to make alternatives be something that's more than just a salesmanship of our rights-abiding nature? So it's a key problem. Also, we had a good example yesterday about bolstering the logic of detention itself. Mr. Silvestri said that in their interviews with interior ministries, they said that they needed detention as a stick to make sure alternatives are effective. Somehow, alternatives exist in an orbit that is detention. And as long as we're in that orbit, we may not get beyond detention. And I think that is something we need to think about critically. Okay, so ways forward. I think ultimately, if we're going to think about effective alternatives, we always need to think about alternatives as being paired with some form of prohibition. Because if it doesn't exist, the prohibition, then it really is not a measure that will lead to ending detention. Logic demands that. Otherwise, what are we talking about? So the case of Belgium is a really good lesson to keep in mind. They had what was arguably one of the best cases of alternatives for families, which was that they had a policy of generally, in principle, not detaining families for the first instance and placing them in the community. And that worked in most parts of Belgium, although some jurisdictions, because the law didn't stipulate that it was prohibited in the first instance, they said, we don't have to actually abide by that. And then when the pressure mounted, they could easily eliminate it, which is, as we heard yesterday, what they've done. So I'll just end with a question. It may be, as we heard yesterday, that we aren't ready for the ending the detention of children. But when are we ready? It may be that states say, well, what do we do if we can't have alternatives? And I think you could go back and say, well, wait a minute. Haven't we all just agreed that it damages children for life? So, do we need to find an alternative to alternatives? I think of the campaign to ban landmines, right? Were countries convinced that they needed to find an alternative to landmines? So I think at some point we will need to move beyond alternatives. Maybe it's not today, but it will have to be someday if we're going to end the detention of children. Thank you very much.
Thank you very much, Mike. And I must say you gave us some food for thought. And we have a short time for discussion. And first, I will ask if there's someone in the audience. Yes, monsieur?
Yes, thank you, Jean-Michel Gaudron, the International Conference of NGOs. In the day of the general debate of the 20th of September 2012, in the Committee on the Rights of Children, a global study was advocated in order to have a look at the at the reality of the detention conditions involving children. And a certain number of NGOs, in fact, sent out a petition so that funding be allocated for this global study to help member states to fulfill their obligations, and that this should really be a catalyst for the development of alternative measures to detention. And in order to have an impact, various savings to be made and the various advantages that could be made. Now, do you believe that such a global study might be interesting, and do you think that it would be a welcome development if the member states, at least the member states of the Council of Europe, could participate in funding this study?
Thank you. I wonder if there's someone in the panel. As for the funding from the Council of Europe, I think no one here can help there. But Maciej? No? Frank? No one feel tempted to say something, but definitely you raised an issue that I think we should consider, and perhaps not being able to give the answer here, we will take it with us. Yes.
Hi, my name's Angus Mulready-Jones. I work for the Prisons Inspectorate in the UK. We're the National Preventative Mechanism, or the coordinator of the National Preventative Mechanism, and we inspect immigration detention, including those centres holding children. I was interested in the last speaker as well as the previous two, building on this sort of terminology alternatives. And while it sort of always concerned me while looking at these facilities that we don't use the welfare sector as or it is less prominently compared to the welfare sector, where in many jurisdictions you would still have detention of children in a welfare sector, but it would be no way considered the norm. So if you use the UK again as an example, we have 70,000 looked after children, and at any one time, about 60 or 70 of them will be detained by local government agencies. And I think the analogy, I mean, being from a prisons inspectorate and inspecting these facilities, maybe I'm doing myself out of a job, but the analogy of moving them towards the sort of prison market, which is considered as a norm, seems to me slightly a strange way of categorising these individuals. The other thing that I would say in terms of sort of eliminating or ask a question is about this point that came up yesterday. So around, I would like to ask a question around the is sort of the elimination of all detention the goal, or is it a neat slogan? I think there are places where for short periods of time there is a need for detention. I mean, there is on paper in the UK we have eliminated child detention, but we still detain people to the airport, and I think that those, I think this is more nuanced than the sort of slight binary debate around the ending or otherwise of detention.
Thank you. Anyone who feel tempted to reply? And Maciej?
I mean, UNHCR's policy is quite clear on that, and when we are talking about children, they should not be put in detention. So I don't know what really to add to that, but the thing is, no children in detention. And there should be proper care arrangements available that will respond to specific needs of children, including unaccompanied and separated children, but also children with families. So that would be my answer to that.
Thank you. I have two more requests. First, the woman on the third floor, and then the man in front.
Denise Graff, Amnesty International.
Amnesty International Swiss section. The main problem I observe when it comes to asylum seekers who have been rejected is a very clear lack of a dialogue. There is no genuine dialogue between the authorities and the rejected asylum seekers. They're simply summoned after the negative decision, and then they're asked a question regarding their departure towards their country of origin. And when they say no, this in fact is an indication for the authorities that they do not agree, they do not wish to leave Switzerland, and that's a ground to detain them. And that, of course, does not suffice. Very often I've seen in dialogue with the rejected asylum seekers, when they're asked, under what conditions would you go back to your country of origin? Very often I have heard very clear answers. They're not complicated at all. May I give you an example of a Bosnian woman who in fact came to see me and who said to me that she couldn't go home. And I asked her a question regarding her safety, and she said it wasn't actually a question of safety. And I said, well, what would you need? And she said, a little machine to manufacture pasta. And she left with that machine, and today many families are living off her little business. And I believe that the authorities should in fact open a real and genuine dialogue with these people far more regularly. And for example, in Geneva, you have the Red Cross Bureau to help people to return, who in fact do that work in the place of the state authorities, which in fact for their part simply take the restrictive measures and therefore which do not have much credibility vis-à-vis the asylum seekers to fulfill that role.
Thank you. This was more a statement than a question, perhaps, but if there's some who wants to comment, you are free to do it. Yes, Frank?
Yes, thank you. Thank you very much for this statement. As Mr. Ruud has said, we will take due note of this. And I'd like to say that in the report, we focus on that issue, the lack of a dialogue. I spoke about the need to build trust. And obviously, a dialogue is the best way of building that trust. We also alluded to the inquiries which have been carried out to see how this spirit of trust can facilitate return. And your example has just, in fact, borne me out in that. And I think that we need to look at that in greater detail. Thank you very much for your comment.
Thank you. And then, sir.
Thank you. I would like to react a bit to Michael's presentation. First, to change a bit the quote you put in my words. What I said is that some transit countries in the Balkans don't detain people because they want to see them moving forward. It was not about alternative to detention. It was about facilitating transit rather than detaining people. I'm not sure. I mean, I tend to agree. Everybody would agree, or many people would agree, that we don't want detention at all and that prohibition is better. But you know, we had lots of people explaining to us that we are far from that for the time being. So I'm not sure what your presentation aimed at, because I still prefer an alternative to detention, even if the debate is not properly framed, even if, you know, liberty should be the rule and not the alternative. I still prefer that than detention. So I'm not sure, you know, to follow your thinking. Of course, prohibition is better, but if it's not happening, what do? We just leave the kid in detention, or we look for alternative? And I think what is key when you discuss, and some of them are here, with border guards or with Ministry of Interiors in charge of this, is also to offer concrete solutions to the problem they ask you. And some are difficult. One of your colleagues just mentioned problem at airport. So if you don't authorize Ministry of Interior or border guards to detain children at border, what does that mean? Does it mean that they have to accept on their territory any children coming in? Or do we have a concrete option for that? When border guards arrest in a green border in the mountain or in the forest 40 people with a smuggler and there is a kid with them, if the kid doesn't agree to follow the border guards, doesn't agree to wait in a police station until a guardian is appointed and is able to come in, what do? You release the kid and you let him go away with the smuggler? So I don't know if you call this alternative or not, but I think these are these concrete situations that border authorities, that Ministry of Interior face, to which we need to bring a viable solution.
Thank you. Mike.
Good questions. And thank you for the clarification on your comment yesterday. I think that I made my point quite clear, which was that I'm asking the question, can alternatives to detention as they're currently framed and used and promoted contribute to ending the detention of children? And I've argued that I don't think they can be. So that is one point of that. Okay, so that's one point. So in response to that, two things. So one, regarding the border guard situation, regarding the situation of the airports, regarding the fact that it's challenging for us to talk about what is immigration detention of children. It's quite complicated question to address in some ways, especially limit cases, especially cases where you're looking at traffickers and that may be involved in the movement of a child. Some level of deprivation of liberty will occur at borders. I think that what we're talking about here in general is the use of detention for long-term custodial situations where we see that this is hurting children, right? So I think that we can analytically make a separation between the kinds of cases you're talking about and I think the larger agenda that is being discussed here today. So that's one thing. But the other thing I would say is that I did try to propose, maybe not too well, framing alternatives in a way that could lead, and I think UNHCR has done a good job in some of this, in its comments on the case of Malta, for example. Alternatives to work, and that means to work in terms of limiting the detention of children. Okay, so this is the perspective I'm using right now. This is the lens through which I'm assessing alternatives. They have to be paired with some level of prohibition. It may not be end the detention of children and let them all free, but it can be, as the case of Belgium was, in the first instance, we will not place a family in detention in principle. Instead, we will find a home, they have a home in the community with other aspects. And it was by pairing the two, the alternative with a limited form of prohibition of some kind, did we see a decrease. And it was only because you paired the two. And I'm not saying end prohibition and let's all say, no, you don't detain anybody ever. I'm not saying that. I am saying, though, that there must be some level of prohibition, some level of we won't detain somebody, some category, for certain reasons until the exception is met. And that's paired with an alternative is a way in which we can see alternatives moving forward in terms of limiting the use of detention. Those two must be paired. But let me reiterate, it's not absolute prohibition, right? But there must be that aspect in the law policy framework.
Thank you. Sorry. Yes, we have one more there.
Hello, good morning. Lucia Rybová, Czech Helsinki Committee. First comment, and then I hope it's the big question. It's leading to the implementation of now prepared alternative measures to detention. So first question is, comment is, in many countries, the police force and army is employed to work with migrant children and with migrants. Are these forces mentally and so on prepared to implement any alternatives which are in general lead to social workers, psychologists, etc., which also it's continuing, discussion to also existing situation in many states in Eastern Europe, who are factually, in fact, detaining their citizens in many institutions because they are not prepared to community services. So the question is, I mean, how you want to train police forces who are now in first row, you know, to work with migrant children. Thank you.
Thank you. Maciej, you want to... Training is definitely important here. and to train the police and military forces to contact and apply specialists and not solve all the problems themselves. But Maciej.
Okay, so I think there are two issues that should be mentioned here. So first of all, yes, training and awareness raising, capacity building, that is specifically tailored for certain authorities that work on the field related to asylum and migration. But I think what is crucial here is to have a special referral system in place. So there should be different actors involved in providing assistance to asylum seekers and to migrants. So it's not only about training and raising awareness about this issue, but also finding partners that could serve together to provide proper care arrangements for asylum seekers and especially for those persons who are in situations of vulnerability and risk, including unaccompanied and separated children. So it's something broader than just training. It's a matter of proper referral system in place, which should be there.
Thank you. Our time is running up, but we should try to look briefly into some of the questions that has been pointed on the slide. The first, if one takes the comparison with alternative measures in criminal law further, is it a problem that it is usually not a court who imposes the detention of migrant kids? I would like to perhaps also alter the question a little. Shouldn't it always be a court who decides upon this? Any of you who wants to comment? Maciej?
I mean, yes, there should be a special authority responsible for issuing decision in each and every case. If we are talking about detention, yes, definitely there should be an authority specialized in that, in issuing decision.
Maybe I can add one aspect. I think it's interesting if you look at the European Convention on Human Rights. For detention on remand, Article 5 requires the detention judge to take the decision. Of course, the proposal is made by the prosecutor office. It is not a judge. The prosecutor makes the proposal, but it has to be the detention judge who orders. But this only relates to detention on remand. And maybe one could say the convention, when it was drafted in 1950 or before, the problem was not as it is now. And I think it is an interesting idea to say maybe also in the migration field, this would be good to have the decision taken by a judge and not only the possibility to go to a judge, because there you have the problem of accès au droit, which I have mentioned just before, that it is difficult for these vulnerable people to make the application before the judge. So I think it is a very interesting point, but I agree completely with what you have said as well.
Thank you. Our time is up. There's still a lot of interesting questions that could be raised. Some of them on the list are directed at one of the speakers, and you who have raised it could perhaps in the coffee break go directly to Maciej or Mike and repeat the questions. I think we have to stop now, and I would like to take the audience and especially the three speakers for their interventions. And now it is time for coffee.